All right. Good afternoon. My name is Palomar Sanchez. I am the staff attorney for the City of Richmond Rent Program. This is the presentation on owner move-in evictions. The date is February 24th, 2023. All right, so these are the discussion topics. We will be discussing the just causes for eviction, eviction noticing requirements, owner move-in requirements and protections, relocation payments, the City of Richmond's urgency ordinance, and some final tips. So first is the just cause for evictions. So residential tenants can only be evicted for one of the following just causes, and the notice must state the reason. This is for partially or fully covered units in the City of Richmond. So first is a failure to pay rent after having been served a 3-day notice to pay or quit. Breach of lease, if a tenant continues to violate the lease after being warned in writing to cease. A nuisance, which if a tenant continues to cause a nuisance after being warned in writing to cease. Failure to give access, if a tenant continues to deny landlord lawful entry per Civil Code 1954 after receiving a written warning to cease denying lawful entry. Temporarily vacate in order to undertake substantial repairs. Remember that this is a temporary eviction, not a permanent one, so the tenants must be allowed back in. Owner move-in eviction, withdrawal from the rental market, otherwise known as the Ellis Act, and a temporary tenancy, which is specific to single-family homes where the owner resided in the property prior to the tenancy, and the tenancy can only last up to 1 year. So this is the noticing rules per Rent Board Regulation 1001. And this essentially applies to any type of termination of tenancy notice. The landlords must submit a copy of any termination of tenancy notice served on a tenant within 2 business days of serving a tenant, along with a proof of service. The termination of tenancy notice should be submitted online at the website there on the screen. For properties with 5 or fewer units, the landlord may submit the notice by mail. Failure to file the termination of tenancy notice timely may be asserted by the tenant as an affirmative defense in an unlawful detainer eviction proceeding. Okay, so evictions for owner or owner relative move-in, otherwise known as OMIs. So this is where the owner wants to recover possession of the rented unit as a primary residence for the owner's spouse, children, parents, or grandparents of the owner. An owner in this section is considered an actual person who has at least 50% recorded ownership. An eviction for owner move-in cannot occur if the same owner or chosen relative already lives in a unit on the property, or if a vacancy already exists on the property. At all times, an owner can request a reasonable accommodation if the owner or chosen relative is disabled and another unit is necessary to accommodate the person's disability. And a note there at the bottom says that tenants have a first right of refusal to return to that unit if it's ever placed back on the market in the future. All right, so here are the noticing requirements specific to owner move-in eviction. So first of all, the tenant must be served with an owner move-in notice, a termination of tenancy. Those forms may be found or downloaded on our website or by using the link on the screen. An owner must give a tenant at least a 60-day written termination notice if the tenancy has been in place for more than 1 year. If it's less than 1 year, it only has to be at least 30 days. Within 2 business days after serving the tenant a termination of tenancy notice, the landlord must file a copy of the notice with the rent board with the completed proof of service. Failure to do so renders the notice of termination null and void. Here's some additional owner move-in requirements. So the person moving in shall move in within 90 days after the tenant vacates and must occupy the unit as a primary residence for at least 36 consecutive months. So they have to move in within 3 months and then stay there as a primary residence for at least 3 years. The owner must pay 1/2 of the applicable relocation payment, which we'll get to in a second, within 3 business days after the tenant has informed the owner in writing when the tenant plans to vacate. The remaining half is due within 3 business days after the tenant has vacated the unit. If the owner or chosen relative fails to occupy the unit within 90 days after the tenant vacates, the owner shall offer the unit to the tenant who vacated and pay the tenant all reasonable expenses incurred in moving to and from the unit. In a rent control property, if the tenant moves back to the property or the first intervening tenancy, the rent charged must revert back to the level paid by the displaced tenant, and the owner may be eligible to apply applicable annual general adjustment rent increases. The landlord must provide the tenant with proper noticing requirement for rent increase. So essentially, if a tenant moves back, or if any tenant moves in directly after an owner has lived there, they will get the similar rent level that was paid by the displaced tenant plus any applicable annual general adjustments. For a non-rent controlled property, if the tenant moves back into the property, the owner may apply rent increases. And that's because landlords are not restricted to the AGA rent increases, but they still must provide the tenant with proper noticing requirements. Here are some protections for seniors or disabled persons from owner move-ins. So an owner may not evict through owner move-in if the tenant meets the following criteria. 1, they have resided in the rental unit for at least 5 years, and 2, is at least 62 years old, disabled, or is certified as being terminally ill by the tenant's treating physician. An owner may evict a tenant who is protected, essentially overriding these protections if the owner or chosen relative also meets the same criteria and no other units are available. Okay, so here we're going to talk about the permanent relocation payments associated with owner move-ins and withdrawal from the rental market. So this payment must be provided to tenants whose tenancy is terminating due to owner move-in or withdrawal from the rental market, otherwise known as the Ellis Act, or under extenuating circumstances due to governmental orders to vacate or health and safety conditions. The notice of entitlement to relocation payment must be provided with the notice of termination of tenancy for owner move-in and withdrawal from the rental market. So it's a specific page or paper or document that we have that you can include in your packet. The amount of the relocation payment is determined by a resolution of the Richmond City Council, and here are the amounts. So for 2023, the top gray box has to do with owner move-in. So as you can see on the left, there are 3 types of units: studio, 1 bedroom, or 2 or more bedrooms. Then there is a base amount, and then there is a qualified tenant household amount. And just to remind everyone, a qualified tenant household is any household that includes at least 1 tenant that is a senior citizen, disabled, or has at least 1 minor dependent child. And I believe it also includes certain poverty line. If it's a low-income household, it may also qualify as a qualified tenant house. All right, let's see. So as you can see, the base amount for for a studio is $4,177.01. Qualified tenant house amount is $4,852.86. For a 1 bedroom, it's $6,449.74. For a qualified tenant household amount, it's $7,431.79. For a 2 bedroom or more, so this could include 3 or 4 bedrooms or more, the base amount is $8,783.46, and the qualified tenant household amount is $10,072.94. Post owner move-in requirements. So this is under Regulation 1010. First of all, there's an initial certification. So a landlord who evicts a tenant, or where a tenant vacates following a notice for OMI, whether or not the notice is withdrawn, must submit to the rent program a completed certificate within 30 days of the tenant vacating the unit. This certificate is mainly for the landlord's contact information and details about the departed tenants. Then is a statement of occupancy. So within 30 days of occupancy, the landlord must file a statement of occupancy attesting to the occupancy in addition to any evidence of occupancy as required by the rent program form. A continued occupancy certification is required every 12 months from the initial move-in date for 36 months or 3 years. The landlord must submit a certificate that the landlord or their qualifying relative continues to reside or not reside in the unit as a primary residence. All of the above forms can be found on the rent program website on the owner move-in information page under termination of tenancy tab. Lastly, we're going to talk a little bit about the urgency ordinances. So in March of 2021, the Richmond City Council adopted Urgency Ordinance 02-21, otherwise known as the Eviction Moratorium, which established a temporary moratorium on certain evictions of residential tenants in Richmond through the local emergency and 60 days thereafter. While the urgency ordinance is in effect, landlords are prohibited from evicting tenants in certain circumstances. This version of the ordinance allowed only 3 grounds for eviction. However, on October 25th, 2022, the Richmond City Council amended Urgency Ordinance 0221 by passing Urgency Ordinance 1322 to allow owner move-in evictions. These changes took effect on November 25th, 2022. Under the newest version of the urgency ordinance, there now exists 4 grounds for allowable evictions while the ordinance is still in place. And the first 3 are the same, which is a nuisance which poses an imminent threat to health or safety. The tenant has failed to pay rent. And the Ellis Act, which is to remove the property from the rental market. And finally, the new addition is where the termination is necessary, where the owner or qualifying owner relative intends to occupy the property to perform an owner or relative move-in. So those are currently allowed. Finally, we just have a couple tips. First of all, you definitely want to speak to an attorney. Evictions can be highly technical and very specific. They also have a kind of a quick turnaround time. And so there's a lot that happens in a short amount of time. So it's highly recommended to consider speaking to legal counsel to better understand the process and current law and to possibly have the attorney represent you in court. Learn about tenant and landlord responsibilities and educate yourself about both California and Richmond eviction laws. No fault evictions such as owner move-in and withdrawal from the rental market can be and usually are complicated. No fault evictions require special noticing, permanent relocation payments, and may provide special rights to the tenant, such as the right to move back in at the rent paid when the tenant vacated the property and protected status for qualified long-term tenants. So if you are a landlord, contact the Richmond Rent Program if you are considering issuing any of these notices or documents. The eviction process has firm deadlines, which if not met can lead to a tenant being evicted. And so, these deadlines are super strict. And even if you are correct in terms of the substance of your case, if you don't meet these deadlines, your case will very likely get dismissed. If an unlawful tenant complaint is received, tenants generally only have a certain amount of days to respond with an answer to the unlawful detainer. If a tenant does not file the answer to the unlawful detainer with the court within the allotted time, the judge may enter a default judgment against the tenant if the landlord requests one. Thank you very much. We appreciate your participation. As always, you can always contact the Richmond Rent Program at 510-234-7368. You can email us at rent@ci.richmond.ca.us or visit us at www.richmondrent.org, where you can set up your own appointment and request to speak to a counselor. Thank you very much. Have a good day.